partager leurs expertises en groupe. Ils sont I would like to welcome everyone who is logged on to follow the debate on the Articling Task Force's final report. As we did last month, we have a number of lawyers and legal commentators joining us in the media room to provide their opinions and expertise as part of a discussion panel. These individuals are Lee Akazaki, a lawyer and former president of the Ontario Bar Association; Doug Ferguson, a lawyer, University of Western Ontario Law, Western University Law Professor and Director of Community Legal Services in London, Ontario; Omar Redai, who is a lawyer, a candidate in the candidate in the LLM program, and a social media and Canadian legal issues enthusiast; Jasminka Kalabzik, who is a lawyer, University of Windsor Law Professor, and co-author of a legal text on class action law; Mitch Kowalski, a lawyer, the founder of Law Tech Camp, and the author of Avoiding Extinction, Reimagining Legal Services for the 21st Century, and he regularly writes for the Legal Post; Catherine McKenna, a lawyer, the co-founder and executive director of Canadian Lawyers Abroad, and the author of several articles about articling; Antonin Privatek, who is a lawyer and a blogger; Gary Wise, a lawyer and a blogger; Eric Valele, I think I pronounced that correctly, who is a student, law student at the University of Ottawa; and Julie Lasson. Julie est une avocate bilingue et un membre du barreau du Haut-Canada et du barreau du Québec. J'aimerais remercier toutes et tous les panélistes qui ont pris du temps aujourd'hui pour suivre le débat. I'd like to thank all of the panelists for returning and taking time to follow the debate. Comme le Conseil le sait déjà, notre ordre de jour est difficile. Nous avons réservé 4 heures ce matin pour débattre le rapport du groupe de travail sur le stage voie d'accès à la profession, plan directeur de la réforme de l'accès à l'exercice du droit en Ontario. Cet après-midi, nous débattrons du budget. Le rapport sur les voies d'accès et le budget ont généré beaucoup de publicité. Nous ne devrions pas être étonnés. Ils présentent de gros défis quand on gouverne les professions juridiques dans l'intérêt public. Je sais cependant que les membres du Conseil ont discuté pendant de longs mois et même des années des questions qui sont soulevées dans cet ordre de jour. Nous avons discuté de ces questions avec nos collègues de la profession et du Conseil. Nous avons écouté ce que les gens avaient à nous dire sur ces problématiques. Nous sommes parvenus à des conclusions divergentes dans certains cas. Alors, aujourd'hui, nous débattrons de nos différences et, avant la fin de la journée, nous avons pris des décisions difficiles. Cependant, peu importe ce qu'elles sont, que nous soyons d'accord ou pas, ces décisions représentent la sagesse collective du Conseil. As Convocation already knows, we have a difficult agenda today. We have set aside 4 hours this morning to debate the report of the Articling Task Force, Pathways to the Profession, a roadmap for the reform of the lawyer licensing process in Ontario. This afternoon, we will be debating the 2013 budget. The Pathways report and the 2013 budget have generated significant publicity and public interest. this should not surprise us. They present significant challenges for us as the governors of the legal professions in the public interest. I know, however, that members of Convocation have discussed the issues raised on today's agenda for many months, if not years. We have discussed the issues with our colleagues in the profession and in Convocation. We have listened to what people have had to tell us about these difficult issues. We have come, no doubt, to different conclusions in some cases. So today we will debate our differences, and before day's end, we will have made some hard decisions. In the end, however, whatever these decisions may be, whether we individually agree with them or not, the decisions will represent the collective wisdom of Convocation. As the chair of Convocation and as the treasurer of the Law Society, I have every confidence in each of you that you will, again, listen closely to what is said on the floor of Convocation. I am confident that each of you will, again, keep an open mind to the views of others in Convocation who may differ from your own personal opinions. I am confident that our debate will be vigorous, interesting, informative, but ultimately courteous and resolute. I need not remind members of Convocation that although most of us have been elected by members of our professions, we owe no allegiance to our constituents, because we are elected not to serve those who have elected us, but rather to serve the public interest. I know that all of you will keep the public's interest exclusively in your mind as we move through the significant items on our agenda today. Because the issues we will be debating today are controversial, and because all of you have the right to engage in the debate on the floor of Convocation, I would ask each of you to remember that, in fairness to your colleagues, you should try to keep your remarks as succinct and as concise as you can. I would also ask members of Convocation to avoid as much as possible repeating any points that may have been made by other speakers. I am sure you will all attempt to follow this advice, but please do note that I will not hesitate to intervene if I think a speaker is going on too long or repeating previous points unnecessarily. Finally, I would like to remind all speakers that during the debate on the Pathways report, they should move to the podium before speaking, otherwise the camera will not be able to pick you up. I would now like to turn to the debate of the Pathways report and remind benchers that on October the 25th, we began consideration of the report with presentations of both the majority and the minority views. And before I ask Ms. Miner to introduce today's debate on the report, I'd just like to indicate that one of the other motions that was introduced at last Convocation by Mr. Faulkner, seconded by Mr. Goldblatt, has been withdrawn. And as you know from your board books information, they have substituted the withdrawn motion with a new motion that will be heard after the debate on the Pathways report. And if I could just have Mr. Barrow read the new motion that will follow the motion on the Pathways report, and I can let everyone know that it will be available for those who are following the debate on Twitter. Our staff will be making it available through that media. Mr. Barrow?
Treasurer, the motion reads that in recognition of the necessity to defray the cost to licensing candidates of the licensing process, Convocation shall approve an appropriate member contribution to the cost of the pilot project to be recommended by the Professional Development and Competence Committee once the costs of the pilot project are determined by that committee and recommended to Convocation as a matter of implementing the pilot project.
Ms. Miner.
Good morning, Treasurer, benchers, and colleagues everywhere. I'm pleased to follow the presentation of Mr. Anand and Ms. Matheson and Mr. Mercer with respect to supporting the Articling Task Force Majority Report. And I don't want to repeat the outline, which was very well put forward last day. I do want to emphasize certain points and comment also on what has happened since we last met. We were adjourned in order to permit further consultation and submissions from the profession. It also gave us an opportunity to have further discussions with our colleagues. And I would suggest that this is one of the benefits of democracy, that we want to consult as much as possible. We need to take into account other views, including dissenting views, and the engagement that we have observed from the profession and from our colleagues here is very promising and positive indeed. Dissent is not necessarily an evil at all. It is an opportunity to enrich our thoughts and our approaches, and I suggest to you that is what has happened. It was unfortunately not possible to reach a full consensus on the proposal that's going forward. However, I think that there are many commonalities between the minority report and the majority report, and particularly the good faith that has been put into both to try and address what is the best way of improving our licensing system. And I'd certainly like to emphasize to those who were not involved that it was, from my perspective, while not totally successful, a very positive process, and all persons participated in a very helpful way. It was not a matter of stonewalling or intransigence, and I would not want anyone to get that impression. One of the matters that came to our attention in both the consultations and discussions was that we learned that we were not as clear in the majority report as might have been, and some of our issues which raised concerns could be allayed really through greater clarification. And on one particular matter, it was our view that there should be an amendment to the proposal, the motion that's put forward. That is going to be distributed, I think, right now on paper. It is a replacement of one part of the motion that deals with the pilot project and the timing of it. And I understand that it's going to be made available to those outside of the room on Twitter. It's not on board books for convocation purposes. Thank you for that assistance in passing it out. And I would draw to your attention that it is a revised paragraph dealing with the length of time of the pilot project. One of the concerns expressed in discussions was that a 5-year pilot project, given the time it needs to both develop it and then evaluate it, was a very long time for a pilot, and it might in fact have the unintentional effect of entrenching it and not really treating it as the pilot that it was intended to be. It was the intention all along to evaluate as soon as possible, and it was agreed that if it doesn't take 5 years, it shouldn't take 5 years. As a result, this amendment says that the pilot project will be for 3 years. It does provide the opportunity for an extension up to 5 if it's necessary to be able to have a fair and appropriate evaluation. And the wording there will be for 3 years to be extended up to an additional 2 years if the Law Society determines that there is sufficient evidence to properly evaluate the pilot project after 3 years. And that motion was moved by Mr. Anand and Mr. Mercer, and I understand for the record they need to confirm that this revision is theirs.
Mr. Anand, Mr. Mercer? Mr. Mercer?
Yes.
Yes.
The nature of the pilot project, in our view, requires some emphasis. This occasion arises because of a gap in the availability of articling jobs and those who seek them. And it was apparent that that gap was going to continue in the next foreseeable future. As much as it has been called the articling crisis, it has also presented an opportunity for us to improve our system of licensing. That, of course, is designed to both protect the public interest and to be a fair and equitable process and a transparent process for those who are participating in it. And it has presented an opportunity for us as Convocation to adopt innovative paths to the licensing process. Because, however, it will require a major change, one of the recurrent concerns we heard expressed both in earlier consultations and to some extent now was, what about the detail? Can we really make a decision when we don't have more detail? And I say the answer is both yes and no. The task force concluded that one shouldn't move to a major change without more information. And as a result, it decided to recommend a pilot project in order to gather the kind of information that would permit a fair assessment at the end as to what the best path would be. Yes, there needs to be more information of an evaluative nature, and it is an opportunity to compare possible or continuing approaches. Do we need more detail now on every single aspect of the pilot project? No. This is a pilot project. It is a policy determination. It's a policy determination with direction to both staff, future providers, and to inform Convocation as to what the parameters should be. Those parameters and contours are very important, and we believe they are set out appropriately. But this is not meant to be a final blueprint with every single operational detail outlined. It couldn't be. That would, in fact, be counterproductive to the kind of flexibility we are going to need and the kind of refinement and enhancement that we expect will continue as it is developed. This is a measured approach to a very difficult issue which has been presented to us. I want to say more about the co-op part of the pilot project, because that is another area that has received some attention. It's one of the areas where it has been said there is insufficient detail. First, we know a lot about articling and the benefits of articling, and that was our starting point for this proposal. And no system is perfect. Articling itself isn't perfect. However, we heard many voices, strong voices from both individuals and organizations about the benefits of articling, both to the public, of course, and to candidates. And I'm going to just concentrate on a few of those remarks because, to my mind, they inform some of the reasons why a co-op program is a very appropriate and desirable part of this pilot project. The OBA noted, and I'm not going to list all the reasons that every organization is given, so I have selected ones that particularly relate to the benefits of experience in a real workplace. And often those relate to both the learning experience for the candidate and also the benefits in learning and the benefits in developing relationships and awareness. The Ontario Bar Association, in fact, noted the ability to understand what goes on in real time with real-time demands and deadlines. It's an opportunity to be on location and very close to those who are supervising and who can give guidance. It's a low-risk environment which builds confidence. The Criminal Lawyers Association noted, again, that it's an opportunity for personal guidance on professionalism issues, among others, to participate in an experience as what it is like to be part of the local criminal law community, to get to know others in that system, whether judges, crown attorneys, or other defense counsel. The Toronto Lawyers Association noted that practical experience can result in long-term relationships. It can result in long-term relationships either with respect to employment or mentoring, and the ability to make contacts afterwards. The County of Carleton Law Association noted that there is a post-legal or a post-location benefit in the sense that people work with and receive mentoring from practicing lawyers. Academia, in fact, although not unanimous on the issue, have many schools which are recognizing that education of professionals benefits from experiential learning. And it's been increasingly recognized as a significant part of the law school experience. That experience is provided through clinics, again, which benefit the student with respect to learning of a particular subject area, but it is also an opportunity to contribute to the community and enhance access to justice in many circumstances. And I would submit that the co-op aspect of this pilot project gives an opportunity to students to have those kinds of experiences in a real-life setting, and that it is very desirable to include that as part of the program. Now, do we know the exact period of time that is appropriate? Is it 3 months, 3.5 months, 4 months? Obviously, we'll take advice on that. But the principle here is not to know every detail of the co-op program, rather to give appropriate direction for those who are seeking the co-op placements to be able to ensure that students are going to have those kinds of benefits. Again, it will be reviewed at the end of this process. There will be an overall assessment to ensure that although it is 2 streams, it is not second class. This is an important feature that will be elaborated upon by Mr. Anand with respect to the equity issues. But I would like to say that, in my view, it is very important for us to approach this in a positive way, to give it every opportunity to develop into the kind of innovative program that it deserves to be. And it will have an assessment at the very end. That is one of the benefits of a pilot project, and that is what we will do with every ability that we have to ensure that it is a valuable one. The public will be protected also, of course, because At the end of the day, the standards will be the same for admission. There are simply different paths to get there. To my mind, one of the defects in the minority report is that it's not a pilot, and that there's not an opportunity to assess at the end as to the real value of the two different streams which I would submit are actually part of that program. Costs have been raised, and again, Mr. Anand will deal with that. We need costs that are reasonable to both candidates and all those concerned. In my opinion, the motion now put forward by Mr. Faulkner and Mr. Goldblatt is a very important one, and I will be supporting that. The profession should be contributing to the admission of our students and to this project. If I could just conclude then, again, I'd like to emphasize that the disagreement has been a positive one in the sense of both encouraging further discussion and review of the proposals that are being put forward. And although I would urge on you to vote for the majority report, as Chair of Professional Development and Competence, I can say on behalf of the Vice Chairs, Barbara Murchie, Wendy Matheson, and Alan Silverstein, that we look forward to working with everyone as whatever Convocation votes for is implemented. Of course, we will come together. Of course, people will be included in this process, no matter how they happen to have voted at Convocation. This is a process that has greatly benefited from the engagement of everyone, and we certainly hope everyone stays engaged after today to assist us in implementation. So thank you, and I'll turn it over to Mr. Anand.
Thank you, Ms. Miner. Mr. Anand?
Thank you, Treasurer. I wanted to follow up Ms. Miner's presentation to respond, as we must, to a couple of other areas in which the Law Society has received input, in particular since last Convocation. There have been a lot of claims made here and elsewhere that one proposal or the other, as well as the current status quo of articling, has an adverse effect on equity-seeking groups. Some of these allegations were made last Convocation here in particularly colorful language. Like many others in the room, the promotion of equality is something which I have advocated and worked on for a good part of my career on behalf of individuals, advocacy groups, corporations, self-regulating professions, and in public administration. Closer to home, I've often represented foreign-trained candidates in their dealings with the National Committee on Accreditation. What this experience tells me is that when we talk about numbers of a particular group who are included or excluded from a program or a benefit, we need to be careful. Careful not to ignore the plain facts, and careful to recognize the policy implications and limitations we can draw from those facts. In legal analysis and in policy analysis, disproportion doesn't show discrimination or even unfairness. It demonstrates a reason to do at least two things. One is to inquire further and ascertain the cause or causes of the disproportion. In our case, to understand the relationship, if any, with a merit-based standard, which is entry-level competence for practice in Ontario. And secondly, to look actively for measures to reduce disadvantage, however caused, that are consistent with the overall need to ensure protection of the public. As Mr. Mercer said last day, the articling shortage arose because of increases in the three groups of candidates: Ontario-trained, Canadian-trained outside Ontario, and NCAs, trained outside Canada. We must recognize that for many years, until 2010 and 2011, the licensing rates for all three groups was almost the same. between 90 and 95%, and racialized and non-racialized candidates had almost identical levels of placement. It was often said over the last decade that racialized candidates were disproportionately unplaced, but that appears to have been incorrect at the time. Since then, over just the last 2 years or so, a gap has emerged with an increase in the number of NCAs and, not surprisingly, a substantial proportion of the non-Canadian born NCAs remaining unplaced. In March 2012, the numbers were 13% unplaced for Ontario candidates, 23% for other Canadian law schools, 29% of Canadian-born NCAs from Australia, the United States, and the UK, and 52% of non-Canadian NCAs trained, 52% of non-Canadian NCAs trained in these countries, and 78% of NCAs from other countries. You'll see from this that the main distinguishing factor is not race. Candidates from Canadian law schools outside Ontario and NCAs from Australia, the US, and the UK are not disproportionately racialized, yet they have much higher shortage levels. What is common is that they lack economic and social ties with Ontario, including the networks and contacts that are developed in law school, which assist in securing both articling positions and post-call employment. The group that is most disadvantaged is further distanced in terms of background from Canadian society and its marketplace. And make no mistake, moreover, it is the most racialized group. Task force members were aware of these figures. We also know that in any system, there will be differences that will result in one candidate's experience being more highly valued than another's. The current articling system has several tiers. The value of your articles and your chances of getting hired elsewhere depend on where you went to law school, where you articled, and so on. And the bottom tier, presently, is those who can't get articles, so they can't get licensed. The majority proposal gives this group the opportunity to be licensed. It's difficult to see how that constitutes unequal treatment. Yet the minority report says we will create 2 tiers because a candidate who secures licensing by passing Law Society entry standards in an LPP will suffer unequal treatment when asked, this is a quote from the report, "Did you article?" And he or she says no. I was surprised to find this argument in a minority report whose central underpinning is that articling is virtually indefensible, paragraph 211, and should be abolished. The argument also makes the unwarranted assumption that the experts in professional education, including universities and law schools, which have expressed their interest in developing an LPP, whether standalone or integrated into their curriculum, and meeting the standards that PD&C and ultimately Convocation would impose, will risk their brand, their reputations, and their students' interests by presenting anything other than a top-tier practical training course and placement. Quite apart from that, I would submit that the LPP can be an exciting opportunity for the equity group and others, where those who summered at law firms, at large firms, are then sent to the LPP, or alternatively, those for whom articles have been unavailable in social justice organizations, in small firms, in placements outside the large cities, or in family, criminal, and immigration law, and we know that this is the profile, may now get such co-op placements and at the same time provide access to justice. It is no surprise, in my view, that law schools are expressing interest in these very kinds of experiential programs as we speak. and in partnering with firms. Because their students, as well as the market, are driving it. In the majority proposal, we are trying to achieve fairness and at the same time maintain public confidence in the professional standards of entry-level lawyers. We have a serious competence challenge, and that is our core function. We regard the minority option as minimizing professional requirements at the expense of public confidence. That's why I don't support the complete abolition of practical training, nor does the profession, and I believe an informed public would not support it. Almost no one suggested to us that we should license lawyers who have no practical training, as the minority report proposes. Indeed, as the OBA wrote this month, borrowing from the experience of the ABA, that this would just pass on the equity barriers to licensing from articling to the hiring process as associates. That is equality with a vengeance. A uniform race to the bottom tier that the minority proposal creates. Licensing after a 10-week course and no practical training. Moreover, I would argue that the minority proposal has serious equity implications. First of all, two tiers will emerge right away. Sole practitioners, who have historically been disproportionately racialized, are subject to added requirements. Those who have summered at larger firms and are hired back into an environment with mentors and networks will not be subject to additional post-call requirements. Sole practitioners will be on their own with 2 hours per month of mentoring if they can find it. Worse than that, if you're not hired and go out into practice with another new licensee, under this proposal you have no mentoring and no practice experience. How are you prepared to serve the public? That will be the second tier group. So within the bottom tier, which is the entire cohort who receive no practical training under this proposal, you have a lower bottom tier, which present trends about firm size will tell us will be disproportionately racialized. Our responsibility for equity and public protection requires us to reject such a grim future and aspire to a higher level. Let me say a few words about cost. The estimated cost in the majority report is $2,950, the current licensing cost, plus $1,400, the prorated LPP cost, that is prorated across all licensing candidates, plus the cost of the culminating assessment that will be developed under the watchful eye of PD&C and ultimately Convocation. The cost of the bar ad course up to 2005 was $4,735. So we're in the same range. The minority put together some figures just before last convocation that look like the numbers are lower, but there are significant discrepancies. The minority report at paragraph 241 says mentoring or supervision, one of the costs, is for sole practitioners and small firms. The costing document that was then produced only refers to the much smaller group of sole practitioners, so the cost is lower. The minority report refers to mentoring, and the description is ongoing work in supporting the mentee's work for the first few years of practice. The costing document provides precisely 2 hours per month for 1 year. The minority report proposes a culminating assessment with objective, measurable standards at paragraph 234. The costing document makes no mention of a culminating assessment, but substitutes a final evaluation by the mentor and the mentee, presumably at their last 2-hour meeting. it seems clear that the process described in the minority report, which I submit does not meet our regulatory responsibilities, will nevertheless cost just as much as the more robust, nationally compatible, outcome-based certification in the majority proposal. Undoubtedly, there are serious equity challenges to be addressed in coming years. Whether we do nothing, which no one recommends, or we choose reform. We have to attend, and as part of the majority proposal, we have attended to the second imperative that I mentioned at the outset, to take measures to reduce disadvantage owing to factors unrelated to entry-level competence, regardless of what the figures are. The Law Society, under our proposal, would do so in a number of ways. First, by providing an alternative to an increasingly inaccessible articling system by offering the LPP. Two, by working with the law schools, social justice providers, and small firms to arrange skills training and co-op placements. And we note the ongoing movement to institutionalize such experiential training in law schools. Three, by redistributing cost across all licensing candidates. Four, by seeking a reasonable financial contribution at the appropriate time from the profession. You have Mr. Falconer's and Mr. Goldblatt's motion, which I support. Five, by devoting time and resources to a major project which is underway already, the working group on the challenges faced by racialized licensees, which has within its terms of reference entry-level barriers to racialized candidates. Six, by continuing to monitor this program for compliance with equity principles, which are fundamental commitments of the Law Society in any program. And seven, by specifically monitoring the equity implications of these two pathways and collecting data for this purpose throughout the pilot project. All of these are solemn commitments to the advancement of equity to be met alongside the policy objectives of a strong, transparent, practical training system. Thank you, Treasurer.
Thank you, Mr. Anand. I have a speakers list that's growing. Mr. Wright.
Thank you, Treasurer. To people attending by webcast who may not be familiar with how convocation works, we meet 8 times a year in decision-making capacity. It means that if we don't decide an issue on one day, such as today, and we put off a decision until, say, January, it will take in convocation 3 days of debate to accomplish the decision, even though it was spread over 90 days. The key is to focus on the 3 days, not the 90 days. What we try to do in convocation is make wise decisions, not premature ones. For many decades, the profession has absorbed all the students that have applied for articles. The legal profession in Ontario has in fact created jobs for lawyers at a rate greater than the increase in population. The problem is that the law schools are graduating students at a rate that is far in excess of population growth. In the last 10 years, the number of law graduates has increased by 40%, far greater than the increase in population. This has occurred because the central administration offices of the universities having law schools, since about the mid-1990s, told their law schools to do a combination of increased enrollment and virtually not fail anyone, or both. And this was to maximize tuition revenues and grant revenues. I was told that point blank by a dean, and I know that other people have been told pretty much the same thing. The profession has done a great job of absorbing the flood of students, but since the 90s, the law schools are now sending us flood upon flood. Up until now, the absorption has been very sensibly market-driven. It is now proposed that we toss aside market forces as a consideration and instead virtually guarantee a call in Ontario to every student who reaches us through the various pipelines, regardless of whether the market can absorb them. I don't think that is in the public's interest. It is said that the number of articling jobs has increased since we reduced the articling term from 12 months to 10 months. Imagine how many more jobs there would be if we had listened to the 86% of the firms that implored us not to reduce the term, and if we had not made it uneconomical and inconvenient for many firms to take on students. It is said that somehow we have a duty to call to the bar every student who meets the qualifications. It is said that the qualification for articling is possession of a law degree, in effect. In fact, that is not the qualification anymore. The qualification is nothing more than entrance into first year at a law school anywhere in the world. Because virtually no one fails anymore, mere entry into first year virtually guarantees graduation, and if the LPP as currently proposed is adopted, it will mean that mere entry into any first-year law school will guarantee a call to the bar in Ontario to anyone who comes here requesting it. How does one gain entry into a first-year law school program? One can attend law schools here or elsewhere whose entry requirements equal or exceed the standards set in Ontario. And we benefit greatly from people who have come through excellent programs elsewhere and choose to come to Ontario. Do not want to cut that off entirely by any means. But if you cannot meet those standards, you can attend law schools elsewhere in the world with lower standards. You can do an end run around the Ontario standards. It won't matter. As long as you get in somewhere, you will be called to the Bar of Ontario if you show up on our door, at our door. It won't matter how low the standards were, and it won't matter whether the market can absorb them. They will all be guaranteed to call. Is that our responsibility? I submit it is not. Once they are called, then what? A large number of them won't be able to find jobs because the market won't be able to absorb them. But they will then be saddled with crushing debts, and they will have had very little experiential training or mentoring. They will be able to hang a shingle and start delivering to the public a level of service that is very likely to be lower than the level of service delivered by the people we've been calling to the bar for the last several decades. It is proposed to replace much of the experiential training and mentoring with more classroom learning. Now, classroom learning is very important. It has its place. But the students will have already had 3.5 years of that. It is not a good substitute for the kind of experiential training that most people get in most of the articling jobs. There are actually 4 options before us today. 1, we can abolish articling. I think the case has been more than adequately made by Ms. Miner, Mr. Anand, and many others that abolishing articling is not something we should do. So I won't spend more time on it. It's not perfect, but it's the best we've ever had. And if we did not have this flood on top of previous floods, nobody would be talking about abolishing articling. Our second option is that we can adopt the LPP as proposed. We should not do that today for 2 reasons. First, it will create 2 tiers of lawyers. To the extent that some of those candidates could not get articling positions because they were foreign trained or racialized or single parents with 2 kids at home, which hurt their ability to get the marks they might otherwise have gotten, it's unfair to them. And it should be noted that virtually every submission that we received from the groups that are most likely to be affected by the currently proposed LPP were opposed to it. We should heed their views, not ignore them. Second, as I've discussed, it provides an unlimited pathway to an Ontario call, virtually regardless of entry standards around the world and regardless of market forces. Further, once law schools here and elsewhere learn that a call to the bar in Ontario is virtually guaranteed, you can be sure that pressures will mount to further increase law school enrollment here and elsewhere. It'll be to their financial interest to do so. It is pointed out that there has been a reduction in the number of law school enrollments in the United States. But I think an analysis of their market would show that that is too little of a reduction and about 50 years too late. We don't need to use the American experience to inform us. It is said that the LPP as proposed is a start and that we have to do something, or that we can maybe massage it later, fix it later. We should be leery of those things. Once you start down a path, it's very difficult to get off that path because interests become entrenched and expectations are forever raised. We should not start down a path without being more certain than we are today about what the consequences of it will be, both foreseen and unforeseen. The third option that we have today is that we can adopt another option. We have received a number of ideas since October 25th that address the disadvantages of the current proposal. But none of those alternative proposals have been thoroughly vetted yet. To adopt one of them today with insufficient vetting is too risky, especially given the importance of the issues and the consequences of the decision. It was also said to me that the LPP as proposed is the lesser of two evils. Choosing an evil foisted on us by law schools self-servingly increasing their enrollments, it is no way to regulate the delivery of legal services to the public. Some of the ideas that have surfaced since October 25th deserve to be examined properly. And we can do that between now and January, either by means of a newly constituted, with a short timeline, a group to look at it, or by means of one or two committees of the whole, and we have two options for both. We have the Friday before the festive dinner, and we have committee day in January.
Mr. Wright, I just want to let you know that we have a speakers list of about 10 people now.
Thank you.
We could start rounding up.
We have had committees of the whole in the past, not for about 6 or 7 years, and they were about the best sessions we ever had. This kind of issue cries out for that kind of approach. We owe it to the public and to the profession to explore these other ideas in a timely way. Our obligation is clearly to protect the public interest. To do that, we have to address the difficulties that we've all seen in the current proposal. We have time to do it, and we should make use of that time. With respect to the Falconer Goldblatt motion, that really means that the lawyers of Ontario are going to be asked to subsidize the flood on top of flood of students that are being sent to us. Make no mistake about what we're being asked to do. And I have one last comment. I think it would be a mistake to think that greatly increasing the number of lawyers per capita will somehow lower the cost of legal service to the public. That's not the experience in jurisdictions where they have many more lawyers per capita. Too little competition is a great evil, but too much competition can be a greater evil. It drives down ethics, it drives up frivolities, it creates pressures to change the system for the worse, as we've seen elsewhere. The U.S. has twice as many lawyers as we do per capita, and their legal services costs are out of sight. Too many lawyers is as much as against the public interest as too few, and we should bear that in mind today. Thank you.
Thank you, Mr. Wright. Mr. Faulkner? With the people that are, before Mr. Faulkner starts, Would the people on the line, on the telephone, please check to see that they're on mute? At least one person is not muted. So if you could just take a moment and press *6 to determine whether you're muted or not, and stay muted unless you want to be added to the speakers list, and you can raise your verbal hand at the appropriate moment. So would everyone on the phone please try *6? Thank you. Mr. Faulkner.
Treasurer, colleagues, both colleagues here as fellow benchers and colleagues who have tuned in by the different forms of electronic access. I welcome people's participation, and I say that from the point of view of the Law Society of Upper Canada, it should be proud. It should be proud that we have reached the stage where transparency is becoming a principle that is repeated amongst my colleagues. The access that people have to this debate today is proof positive that we are capable of not just joining the 20th century, but we can even flirt with the 21st century. Mr. Treasurer, colleagues, I say this from the outset so it is clear where I stand on this debate. I do not support the abolition of articling. And that, for me, makes the decision tree a little clearer in terms of what I need to do next in order to, as you put it, Treasurer, advance the public interest. My first job, in my mind, is to assess my perception of the public interest. Too many times, Treasurer, these words are bandied about to defend a chosen position in a self-serving way. We all have our version of what the public interest is. It begs the question, who is the public we're seeking to serve? And that's where I respectfully have to disagree, Treasurer, with the notion that the constituencies who put us in place are not an important piece to that. I don't say, Treasurer, that you suggested otherwise, but I do say that I do consider those who elected me to be an important part of the public for whom I must advance the public interest. I also consider those outside of the legal profession and ask myself an important question: who are they as members of the public? And it doesn't matter if it's an analysis that in effect looks at the broader public or the profession. There is something that we experience on a regular basis within the legal profession and outside, and it's called discrimination. And that discrimination and the potential danger of reinforcing a discrimination always causes us to pause when we handle these difficult issues. Let me cut to the chase on why I think this feeds into the debate we're having today. We know that the reality is that as matters currently stand, the status quo has left a group of people unprotected in terms of their professional aspirations. Mr. Mercer broke those numbers down last day, and I appreciate that the quote-unquote NCAs, the National Committee for Accreditation candidates, would appear to exist as a result of their quote-unquote NCA status. But to me, that's like saying that the individuals that get disproportionately pulled over have more tracksuits and running shoes and SUVs than the other people. I'm more concerned on who they are. And what I know in my heart and in my experience is they are not people that are white, that are summering at Bay Street firms. They are different. And so we ask ourselves, as people are left out, as they're on the outside of the bubble in terms of employment and candidacy, how do we ameliorate it? How do we address it? How do we address the disadvantage? And I can't help it, I'm a lawyer, so I'm stuck using law. Any cursory review of Section 15 of the Charter tells you there's two sections, two subsections to it, Treasurer. There's Section 15.1 that provides for equality before and under the law, regardless of race, national or ethnic origin, color, religion, sex, age, mental or physical disability. But 15.2 of the Charter actually provides for the recognition that nothing about our equality provisions excludes affirmative actions or programs aimed at ameliorating disadvantaged situations. Why do I raise this? Because the number one criticism, Treasurer, the number one criticism of the decision to act, which is really what the majority task force report calls us to do, to act, that the fact of creating two streams actually creates a discrimination. What we're really struggling with is we already have two streams. We already have the discrimination going on, and we ask ourselves, how do we now move in order to ameliorate it? Well, the answer is we can't create one stream overnight. Yes, the abolition of articling on its surface is attractive because obviously there is a mechanism by which some are getting the articles and some are not. But I don't believe that that is the only solution. I believe you do have ameliorative programs, you do have programs aimed at the disadvantaged, and that the Articling Task Force Majority Report is prescribing a process where there is an opportunity to start addressing and redressing the wrongs. Do I recognize the reality that taking the course versus articling will create or feed on bias? Yes. And I think those of us who try to debate this on the basis that there is no actual difference in quality are missing the point. We are going to be faced with a bias. There will be people, employers, important employers, that prefer those who article over those in courses. That is the truth. There is simply no point in trying to duck that. On the other hand, we are capable, as the governors of this fine profession, of addressing that bias head on, of actually re-educating people, of actually talking out in the open about it, of educating, of discouraging, of potentially disciplining if necessary. I don't throw out the baby with the bathwater because it's going to be a tough road to hoe. I say I have candidates who don't have jobs today, and I want to get them jobs. And the only way I know of getting them jobs is to get them licenses. I don't want to throw away all of our standards of competency on this issue of candidacy and licensing. So I see the only solution before me, there is no other motion before convocation, the only solution before me as the majority report. I don't have time to wait anymore. I can't spend more time debating this. We have to actually move forward. We have that responsibility. The Equity Committee that I have the honor of being vice chair with Mr. Goldblatt as chair and Ms. Hare as vice chair, is its entire sine qua non is to monitor the impacts of Law Society programs on its profession. We have an obligation to rigorously monitor the implementation of this pilot program. We have an obligation to make sure we're not making it worse and that we're making it better. But that's a challenge, and we have to show up. Finally, I have been worried from day one that we are going to saddle our fledgling lawyers with ridiculous financial burdens in an effort to quote-unquote save articling. This struck me as wholly unfair. For that purpose, and I am closing, Treasurer, because I've been a while, to that end, we have proposed the motion that's at tab 9 of board books, page 382. The motion doesn't have a fee per member as I had originally proposed it. I have been persuaded, and I agree with the thinking that because we haven't created numbers for the motion, as in numbers for the pilot project, creating a number for the contribution is problematic. But anyone looking at the funding motion will know that myself and Mr. Goldblatt, who's seconding the motion, are extremely concerned that we commit today to helping to shoulder the burden. We are not going to remove the financial burden, we're going to help shoulder it. If we do that, if we monitor the impacts on equity, if we take into account and tell the truth about the biases that are out there and re-educate, I believe that the majority report approach, it being the only one before us, is the only way to act at this time, and I thank you for your patience.
Thank you, Mr. Palmer. Mr. Sandler?
Thank you, Treasurer. I support the majority report. I find it to propose an imperfect solution, but the least imperfect of the solutions that have been presented to us. I come at it from a slightly different perspective, perhaps. And I want to start with this, that we have an issue larger than our inability to place articling students. And that, quite frankly, is confidence in our profession. Judges are increasingly reporting that lawyers appear before them without the most basic skills required to serve their clients. An understanding of the law, the skill to question witnesses, judgment as to what to argue and not to argue, ethical lapses, and at times even poor proficiency in written and oral English skills. Access to justice involves not only access to legal advice, but to competent legal advice. And we have to acknowledge at this point that the problem is profound. So I see this issue not only from the perspective of equity and fairness to applicants, but largely through a prism that focuses alike on competency. And that informs my approach to this difficult issue. I see this as not only a difficulty, but as an opportunity for us to now address in a more substantive way that competency issue that has been identified. In my view, the articling experience, when administered by a conscientious and competent lawyer or law firm, surpasses any comparable form of teaching students the art of lawyering. And I say at once that my perspective is shaped by my own articling experience and that of many members of the criminal bar. You can't learn how to practice criminal law from a book. You can't learn it simply from a classroom. You can't learn it from a very short experiential placement. And I believe that that is true for many areas of the law. And I also believe that many people in this room owe their success in the profession, to the experience that commenced with their articles. I also regard articling as an important opportunity to enhance access to justice. Putting on my other hat for a moment, as the chair of the Law Foundation of Ontario, I can advise you that we have seen the articling experience as an important way to contribute to access to justice in this province. Since 2005, we have funded 53 positions at public interest organizations in this province. Amnesty International, Canadian Civil Liberties Association, Eco-Justice, the Barbara Schleifer Institute, and the like. We've also funded a series of connecting articling fellowships, funding 37 positions at community legal aid clinics and Legal Aid Ontario, where students are serving clients directly in their own language, such as Spanish, Arabic, Tamil, Cantonese, or where they're working in rural or remote areas such as Moosonee, where access to justice is poor. So I see articling as a very important way to enhance access to justice, and that is why the Law Foundation has supported that approach. We can't fund the entire gap that has been created. We can only do our part. Now, having said all of that, are some of the articling experiences that are currently offered inadequate? Undoubtedly. But that's hardly a rationale for throwing out the baby with the bathwater. This provides us, as I said at the outset, with an opportunity to ensure that the articling experience is a worthy one. I've always understood that the articling experience for our students involves the creation of an education plan, that it be provided to the society, that it be approved, that we measure articling in the course of the year by adherence to that education plan, and if we're falling short in providing full opportunities for our student, then we improve the articling experience during the currency of that articling. And I see no reason why we shouldn't use this as an opportunity to ensure that the articling experience is the very best that it can be. So I wholeheartedly support, as do most lawyers in this province, the preservation of articles. If I had my preference, we would address this problem perhaps through the kinds of programs that I've identified at the Law Foundation, through incentives to law firms to increase the likelihood that they will provide an articling experience, and through a relook perhaps at whether or not every student seeking an articling position truly meets competency criteria. I'm not convinced right now that our current examination process adequately addresses the issue of competence. We've abolished the bar admission program, and in that we've lost another opportunity to ensure or enhance competence in our profession. So I think one of the things that we have to do, regardless of what we decide to do today, is have a sober second look at our examination process and whether or not we can improve in areas of competence. But that having been said, I agree with what Mr. Nat has said wholeheartedly. Notwithstanding incentives, and notwithstanding enhancements, and notwithstanding a second look at the examination process and whether or not every person who applies is truly competent, we are still left with a current gap. And in my respectful view, it has to be addressed. And the best of the imperfect solutions as to how to address it is the pilot proposal that is suggested by the majority. And I have to say, I'm not convinced that the pilot project will necessarily ultimately be the right solution. There's much in what the minority has said that has given me pause for thought. But I want to see. I want to give it an opportunity to work. As Ms. Miner said, I want to approach it positively and see whether or not it indeed creates a two-tiered system or not, or whether or not it truly provides for levels of competence that protect the public interest. So we've got to give it a chance, and I'm prepared to do that. And it's only because it's a pilot project that I am prepared to do that. And the final comment that I'd make is that I don't think that any proposal necessarily has to accept as a proposition, as Mr. Wright very articulately put forward, that we have to accept, as lawyers in this province, every applicant, whether there's 2,000 of them as there currently are, or down the road 2,500, or down the road 3,000 still. Access to justice does not require that every single applicant, no matter how many the numbers, be accepted into our profession. But I think that's a discussion that we have to start right now. I don't think we can wait 3 years hence or 5 years hence to talk about the numbers. I think we have to start talking about those numbers now. And I would hope that Convocation would join me in having that dialogue with law schools, with the government, with the profession, so that 5 years from now, nobody looks at surprise when we have 3,000 applicants and we question whether or not they serve the public interest. Thank you.
Thank you, Mr. Sandler. Ms. Leeper?
Thank you, Treasurer and members of Convocation, colleagues. I speak to the proposal at pages 6, 7, and 8 of the task force report this morning. This proposal, as I see it, raises three things. It starts with a big picture. It asks us to consider the first of its kind in Canada, an innovative idea, adding a law practice program as an alternative to articling for candidates for licensing in Ontario. Second, it advises caution, and for that reason it recommends the innovation proceed as a pilot project. And third, it contains some detailed specifications on timing, rollout, and length of the course in the pilot project. So I have a comment to make on each of those three aspects. The values that I've applied to the questions before us today are quality in our licensing process, meaningful consultation and respect for the bar, the imperative to rest our policy decisions on evidence and measurable results. So I'll begin with point one, what I call the big picture. The majority proposal is to try a new licensing route to innovate on established pathways to admission to the bar of Ontario. And I never think of it as two-tier because we already have multiple pathways. I think of it as multiple pathways, let's test another. And I do support looking at alternative models, such as an LPP, on a true pilot project basis with two caveats. A recurring theme of the report is the need for caution in the absence of data on questions like the nature and quality of articles for equity-seeking groups, that's at paragraph 87, The insufficiency of evidence to make permanent change, paragraph 91. And I support gathering available evidence and applying methodological expertise to inform each critical stage. The other feature which I suggest deserves our cautious attention over time, if we go down this road, is on whether we will in effect be shifting the market by being the first out of the gate in Canada with this new route to practice. How will increased numbers of licensees affect the quality of justice and cost of regulation? Will there be unintended consequences for the public interest, and what are they? What is our future role as a regulator by our having responded to what may be a symptom of a larger phenomenon in the common law world and across other professions? So this leads to my two concerns with the other parts of the proposal. The proposal is now for a 3 to 5 year pilot project, including gathering data and assessment. But the project affects the entire licensing cohort. The profession may be asked to help defray the cost. Is it truly a pilot project, or is it something bigger? Pilot studies are normally small-scale preliminary studies to evaluate feasibility, cost, and adverse events. They are frequently carried out in advance of larger-scale research to avoid time and money being wasted on inadequately designed projects. And this is the first part of the proposal that does give me pause. As conceived, it's not a pilot project. It's not being measured on a small group or small expense. It really does require us to go all in for 3 or up to 5 years, as it does for candidates, the bar at large, and third-party service providers. Have we satisfied ourselves that we can unplug from this if necessary? And if 5 can become 3 so quickly, I ask, what is the rationale for the number that was before us up until this morning? My third point, the specifics that are attached to this recommendation. The majority proposal includes defined periods of classroom training and a 4-month co-op placement. The country which has led in the development of these sorts of transitional licensing processes, Australia, has 16 practical legal training courses with many variations of the model. Victoria has 24 weeks of full-time study with 15 weeks in the field. New South Wales, 15 weeks full-time study, 15 weeks in the field. Some students can enroll during law school and take courses called Becoming a Practitioner Intensive. The ANU has only a brief in-person requirement, and it's mostly online learning, using mentor supports for students. It's been noted by those who have studied those courses that these are costly courses to get up and running. They need scale for success. In a pilot process, I ask what business model banks on having to shut down in 3 years? And if assurances are given or inferred, what kind of a pilot is it? I was fortunate to participate in the development of the OSGA public interest requirement, a graduation requirement that means students have to do 40 hours of work in the public service to graduate. And prior to OSGA starting that program, for 40 hours for each cohort of students, they very carefully went around to all the possible places, and they gathered up numbers as to how many placements might be available. I'm sorry, but I don't see that work has been done, for example, here for the co-op that we're being asked to approve, or the link. So for me, the rationale for choosing that particular model to implement now is unclear. So this is a big decision. I'm sorry I'm not able to accept the entire package, although I support the big picture idea of looking at other quality pathways to licensing. These might even turn out to be better than the status quo, but we don't know unless we design and measure it carefully and methodically. We are hearing from the profession in great numbers. We are still hearing that a number of sectors are feeling rushed at a key decision point. This engagement is good news. Having asked for engagement, we have it, but we must not waste it by brushing off legitimate concerns, and we should respect the profession by being methodical and giving them the evidence that our motion is based upon. As presented, and with great respect to all members of the task force, I must vote against the proposal in its present form.
Treasurer and colleagues, I would like to make my remarks having regard to the fact that others have raised very important points, and I won't repeat them. The notion of competency, I think, lies at the center of our debate. It's an ancient debate, and it's actually a debate which took place in this room when Caesar Wright and John Robinette were at swords drawn in 1948. The tradition was, the two traditions that were at debate then and remain now is the original American tradition of law schools, which was largely led at the last century by Harvard, and the notion of the English tradition, which was experience, was the only way to learn law. The benchers in 1948 adopted the experiential model, but the law school model also took root here when Caesar Wright left the deanship of Osgoode and went to U of T and created that school, and now we have the debate coming forward in a different way. The debate is this, as far as I'm concerned. Can we say that the lawyers that we are licensing are competent if they have had no real experience? And my view is we cannot. I do not practice family law, but let me take the instance of a family lawyer. A family lawyer cannot give advice without knowledge of accounting, without knowledge of insolvency, without knowledge of mortgages, without knowledge of real estate, without an understanding of humanity, and a host of other matters that come up in everyday affairs in all of our affairs. And so in my respectful view, the idea of the English tradition that experience was essential for competency remains. That doesn't take away from law schools, and let me deal with a point raised by Mr. Wright. The law schools cannot be, nor can the universities in this province or anywhere across Canada or across the world be demonized. This is a celebration that so many people want to study law and so many people want to have a chance to try and practice. And I reject the notion that we have a problem because they have been irresponsible. They have been responsible, it's a celebration. We have an issue, but it's not a problem. The question we have to ask ourselves is then, are we going to jettison a system that works because of increased numbers in market forces? And I say no. I'd like to comment on market forces. The fact is that we cannot, and we are not free, in my view, from a competitive law perspective, to go forward and say our articling program will limit the numbers. That is not a real market. The only real market will be the public who want to retain these people when properly qualified. Our only obligation is not to try and guess where to intervene in the markets. I don't think we should, I don't think we can. So the notion that we would somehow restrict, either directly or indirectly through the articling program, is unacceptable. And my last point, therefore, is I'm in support of the present proposal, but I do believe that the competency issue has to be addressed with a serious program, choose the time, similar to the old Bar Admissions program, where you are given a series of very heavy courses with serious exams at the end of it, and I suggest we can do it all electronically. We don't have to have the same people attending in one place at one time, and they will then be required to pass exams which will be rigorous. Some may not make it, they'll have another chance to do it, but that's the only way that I can see that we can measure the competency before they go and do whatever other program, be it articling or be it the pilot project or something similar. How much obliged?
Thank you, Mr. Campion. Ms. Rothstein?
Thank you, Treasurer. I rise to speak against the motion, but not because I adopt all the tenets of the minority report. I don't. And particularly its support for the abolition of articling. Rather, I cast my vote against the motion because I believe the proposal before us can be improved significantly in a fairly short time frame to address many, if not all, of the critiques that have been levied against the majority report. To become, to paraphrase my husband's favorite politician, a more perfect proposal. It can address the features specifically of the LPP, which in its current incarnation will almost certainly create significant disadvantages, significant unfairness for those who do not obtain articling positions. Let me go back to some of the settled ground just to begin. This decision we confront is unprecedented, as everyone has acknowledged. It is unprecedented for us to be creating a licensing change, even on a pilot basis, that is premised on such unsettled knowledge, data, and groundwork. It is unprecedented to have a decision before us that has ignited so much engagement with our society. It is unprecedented to create so many viewpoints, and frankly, colleagues, it is unprecedented for a decision to be so divisive, not just here, but amongst all of our stakeholders. It has been a charged and emotional and difficult journey. And it seems to me, as I try and step back from it, that the debate has been most charged because of the two polar extremes of the debate. Those who on the one hand say that we ought not to change the status quo, that we ought to think about whether or not we should even be allowing so many into our midst, and those who on the other hand argue quite persuasively in some quarters that we must abolish articling. So much blood has been spilled over those two extreme positions that we have not acknowledged where we are today. I believe that the weight of opinion, not only in this room, surely in this room, but also amongst all with whom we've consulted, strongly supports the position of the majority that we must do something to alter the status quo. That is a fairness obligation we have as a regulator. Of course, the minority shares that view. And I believe the weight of opinion strongly supports the view that we must not, at this stage, abolish articling. That there is too much value, whether we can document it or not, in experiential training to throw the baby out with the bathwater, as the expression goes. But because so much emotion has fomented those two extreme concerns, what we haven't spent enough time thinking about is where that leaves us. If I am right, that mostly everyone in this room would accept that we must change the status quo and we must provide a vehicle by which all who wish to can seek to be licensed by this society. And if we agree that we ought not to abolish articling either because that would cause too much of a furor or because on a principled basis it is wrong, then we're driven to the conclusion that we must create an LPP. I share that view. We must. But the question is, what are its parameters? I am very heartened to see that the majority has suggested, Treasurer, and moved this morning that we have a much tighter time frame in which to evaluate its parameters. I support that. But there remains some fundamental unfairness that, in my respectful view, we would be blind to ignore. It's length. It is 8 months. And the requirement of a 4-month co-op is problematic on at least two fronts. It is far from clear to me that it is workable. It is far from clear to me that it will not rob students of the experiential training that they're getting in the law schools at the moment. It is far from clear to me that it will be something that will really be able to affect around the province. The combined effect of an 8-month program that is very expensive, whether or not it is ultimately financed by some of our profession or not, and the enforced 4 months of unpaid service is surely an extraordinary burden to put on one class of licensees. Why are we doing it that way? I understand the rationale. I understand that the majority has come to the view that there must be, as a sine qua non, some experiential training. I am not so persuaded of that myself. I am not so sure that we couldn't have an LPP that didn't insist on that, or at least was one which acknowledged
that any experiential training in law school counted towards the accomplishment of that goal. And so I say to all of you, if we really allowed ourselves just a little more time to reach some more compromises, to find some innovative approaches to the precise parameters of the LPP, wouldn't we have a more perfect proposal? Wouldn't that be something that would satisfy everyone that we are doing the very best we can do, not just accepting, as we are now, some extraordinary unfairness for one group of our licensees, whoever they may be. So on that basis, Treasurer, with great reluctance and with great gratitude for the wonderful reports that we have before us, both the majority and the minority, I urge my colleagues to think about not supporting the majority position, but acknowledging that we have come a very long way already. We do have considerable agreement, and the debate between us, the only thing remaining to address is the fundamental unfairness of the current parameters of the LPP program. Thank you.
Thank you, Member Rothstein. Mr. Brett.
Treasurer, Venture, colleagues, I rise to support the motion. I have 3 points that I want to make. What is the nature of the problem? What steps should we as a law society be taking to address the problem? And third, what do we need to do here today? Let's start off, first of all, with what the nature of the problem is. I agree with Mr. Sandler. We have a serious competence issue in the profession. We see it all the time in the discipline process. And I say that for many years, the Law Society has essentially abdicated its role in ensuring competency at entry to the profession. Instead, we've been primarily dealing with competency issues through our discipline process. This is not good policy, and it does not adequately fulfill our mandate of regulating the profession in the public interest. As Mr. Wright says, I think it's basically true. Effectively, it's law school admission committees that have been determining who gets to practice law. Few students who are admitted do not graduate. Fewer still do not pass their licensing exam. And in effect, the only real constraint has been the ability to find an articling position. Now, this is not good policy. So I come to the second part of my submission. What steps should the Law Society be taking to ensure competency on entry to the profession? In order to speak to this, we need to look at the 4 different phases that are involved in entry to the profession. The first phase is academic training. A second phase is practical training. A third phase is admission and licensing. And the fourth phase is the early years of practice. Let's look first of all at academic training. We need to ensure that the students have in fact received the academic training necessary through some sort of a proper substantive exam. What happens essentially now is we at the Law Society pretend to tell the law schools what to teach, and the law schools pretend to teach it. I say we should stop trying to tell the law schools what to teach and instead tell them what we will be testing. The second phase, practical training. If a student has passed the substantive exam, I agree with the sentiment of the report that Law Society is obligated to provide adequate practical training. And the current system is not supportable. We can't say that people have shown that they have the substantive knowledge that they can't get into the profession because there's not adequate training. This speaks to the wisdom of looking at a practical law training program, because I recognize that there are not sufficient articling positions and are unlikely to be sufficient articling positions. I also recognize that the articling experience is far from perfect. It's uneven in some times. However, for the vast majority of students who article with a firm and who get hired back or find employment elsewhere, we do not have significant regulatory risk. The real problem is with students who do not get hired back and start out as sole practitioners. This is the area where we need to ensure that the practical skills necessary to run a sole practice are obtained. We need to do a better job at this, and we used to do a better job with the 6-month bar admission course. Let me turn to the third phase, admission licensing. We provide an unlimited license to practice on entry. I am licensed to convey real estate, but clearly I'm not competent to do so. And I'll put aside the comments about whether I'm competent to practice in other areas of law, but I'm prepared to admit that I'm not competent to convey real estate. Essentially, our regulatory scheme is to rely on lawyers to act in good faith and not take on matters they're not competent to handle. This is not good regulatory policy. Most professions don't let people to practice in areas where they're not competent to practice. We need to start considering limited licensing. If the scope is limited, it will allow for a more focused, practical training program. And let me speak finally to the early years of practice. Those that are in firms or employment situations generally get some mentoring. Again, we need to think about how we deliver mentoring to those who are sole practitioners in their early years. Mr. Falconer has suggested this, and I agree it makes sense. So what do we need to do today? To paraphrase Winston Churchill, this is not the end. This is not even the beginning of the end, but it is perhaps the end of the beginning. There is much that we all agree on. I think that there's a consensus that we have issues with competency on entry. We agree that there are problems with articling. There's not enough positions. And importantly, there's a need for practical training following graduation from law school. The minority says eliminate articling now and provide some practical training for all. The majority says put practical training in place, try it out, and leave articling in place for now. I say, given that everybody agrees that practical training is necessary, let's get it up and running before we eliminate a system that works for many people, the current articling system. And if the practical training does work, maybe we can consider at a later date whether we need to maintain articling, but that should not be done now. And I say that this is the first step in a long journey. And we need to consult the profession on each step along the way. But we do need to take the first step. And it's clear to me that the first step is to get started, to put in place a practical training program, evaluate it, and make sure that it works. Thank you, Treasurer.
Thank you, Mr. Brett. I think we'll take our morning break, and we'll come back at 11 o'clock to continue the